Imagine spending years building your life in America, working, paying taxes, raising children, waiting patiently for your green card, only to suddenly hear that a new USCIS policy could force some applicants to leave the United States and return to their home country before their case is approved. Sounds unreal, right? But that's exactly why thousands of immigrants are panicking right now after the release of the new USCIS policy memo PM-602-0199 in 2026. And here's the scary part. Many people still don't understand what changed, who could be affected, and what mistakes might now trigger delays, denials, or even requests to leave the country. Immigration lawyers are already warning applicants to pay close attention because one misunderstanding could completely destroy years of waiting. In today's video, we're breaking down exactly what this new USCIS memo says, why it's causing fear across immigrant communities, and whether adjustment of status applicants could actually be forced to complete processing from their home country instead of inside the US. We'll also explain who is most at risk, what this means for family petitions, employment-based green cards, pending applications, and what steps immigrants should immediately take to protect themselves before it's too late. Because right now, confusion is everywhere. Rumors are spreading fast. And if you're an immigrant, green card applicant, or someone waiting on USCIS in 2026, this update could directly affect your future in America. So make sure to hit that like button right now and stay with us until the end, because the details in this video could save you from making a life-changing immigration mistake. The immigration world in America just got hit with another massive shockwave, and this time, the fear spreading through immigrant communities feels very real. Across social media, immigration forums, law offices, and family group chats, one phrase keeps appearing again and again: PM-602-0199. A new USCIS policy memo released in 2026 is suddenly making people question whether their entire green card journey could be at risk. And for many immigrants who have spent years building their lives in the United States, the possibility of being forced to return to their home country during the immigration process feels absolutely terrifying. The panic started almost immediately after details about the memo began circulating online. Videos exploded across YouTube and TikTok claiming that adjustment of status applicants could now be denied more aggressively or pushed toward consular processing outside the United States. Some people began warning that applicants who once expected to finish everything safely inside America may now face situations where they are told to leave and complete processing abroad instead. Naturally, fear spread fast, because for many families, leaving the United States is not a simple trip. It could mean separation from children, losing jobs, triggering visa bars, or risking being unable to return for months or even years. And this is exactly why this policy memo has become such a massive topic in 2026. Immigration policy changes are always serious, but what makes this situation different is the uncertainty surrounding how USCIS officers may interpret and apply the new guidance. When rules become unclear, anxiety grows. People start wondering if a small paperwork mistake, a visa overstay, or even a previous immigration issue could suddenly become far more dangerous than before. One of the biggest concerns involves adjustment of status applications, commonly known as AOS cases. Normally, eligible immigrants already inside the United States can apply for permanent residency without leaving the country. For years, many applicants viewed this pathway as safer and more predictable compared to consular processing overseas. But now, some immigration experts fear the new memo may encourage stricter reviews of eligibility, especially in cases involving unlawful presence, status violations, or questionable entry histories. And if USCIS determines someone is not eligible to adjust status inside the United States, the consequences can become extremely serious very quickly. Instead of continuing the process safely within America, applicants could potentially be directed toward consular processing in their home country. On paper, that may sound manageable, but in reality, It can become a nightmare scenario for certain immigrants. Leaving the United States after accumulating unlawful presence can sometimes trigger multi-year reentry bars. Families can become separated. Careers can collapse overnight. Entire futures can suddenly hang in uncertainty. What makes the fear even stronger is that many immigrants already feel emotionally exhausted from years of constant immigration changes. Every few months, there seems to be another announcement, another court ruling, another policy update, another delay, another backlog crisis. People who have spent years following every rule are now terrified that the ground beneath them may once again be shifting. For family-based green card applicants, the anxiety is especially intense. Imagine a spouse of a U.S. citizen who has been waiting patiently inside America while building a life with their family. They may have children in school, a stable job, and deep roots in their community. The thought of suddenly being told they may need to leave the country to finish processing abroad feels devastating. Many fear uncertainty more than anything else, because immigration processing overseas can involve delays, administrative processing, embassy backlogs, and unpredictable timelines. Employment-based immigrants are also watching this situation very closely. Skilled workers who came to America on temporary visas often spend years waiting for green card approvals. Many have built entire careers around the assumption that their adjustment of status would allow them to remain in the United States during processing. If stricter USCIS interpretations now create additional obstacles, some applicants fear their professional lives could be thrown into chaos. Employers may hesitate, visa renewals may become stressful, families may suddenly face difficult decisions about whether staying in the U.S. remains safe. Another reason this story exploded online is because immigration misinformation spreads incredibly fast. The moment people hear words like forced to leave America, panic naturally follows. But here's the important part. Not every immigrant will be affected equally. The actual impact depends heavily on individual immigration history, eligibility category, prior entries, visa status, unlawful presence issues, and several other legal factors. Unfortunately, social media rarely explains these details carefully. Instead, fear-driven headlines often create confusion that makes the situation seem even more dramatic than it already is. Still, immigration attorneys across the country are warning people not to ignore the memo. Even if some online claims are exaggerated, policy guidance changes can absolutely affect how officers review cases. And when officers receive new instructions emphasizing stricter scrutiny, applicants need to be extremely careful with documentation, eligibility requirements, and legal strategy moving forward. One of the biggest mistakes immigrants make during moments like this is assuming their case is simple when hidden complications may exist. A person may believe they qualify perfectly for adjustment of status, only to discover later that a prior visa violation, unauthorized work history, or entry issue creates unexpected problems. Under stricter review standards, these details can suddenly receive far more attention than before. This is why immigration lawyers are now strongly encouraging applicants to review their entire immigration history carefully before filing anything new with USCIS. Even old records from years ago may become important. Travel history, entry dates, visa categories, previous denials, expired status periods, and employment records could all play a major role in determining how safely someone can proceed under the updated policy environment. Another issue adding to the fear is the growing backlog crisis within the immigration system itself. USCIS processing times remain painfully long for many applicants in 2026. Some people have already spent years waiting for interviews, approvals, work permits, or visa availability. When new policy uncertainty enters an already overloaded system, stress levels rise dramatically. Immigrants begin worrying not only about approval, but about whether delays themselves could increase exposure to legal risk. And then there's the emotional side of all this, something many policy discussions completely ignore. Behind every immigration file is a real human being, real marriages, real children, real dreams. People sacrifice enormous amounts to build a future in America. Many leave behind family members, careers, and entire lives in pursuit of stability. So when a policy memo suddenly creates fear about deportation risks or forced departures, the emotional impact becomes enormous. Social media has only amplified these fears. Viral videos with dramatic titles are everywhere right now. Some claim mass denials are coming. Others warn immigrants to stop filing immediately. Some even suggest the government is preparing for aggressive removals tied to green card processing. While not all these claims are accurate, they reflect the deep anxiety many immigrants currently feel. At the same time, immigration attorneys are trying to calm people down while still urging caution. Most experts agree that applicants should not panic blindly. Instead, they recommend understanding exactly how the policy applies to individual cases. Because immigration law is incredibly fact-specific, two people may appear similar on the surface, but face completely different legal outcomes based on tiny details in their records. For example, someone who entered the United States lawfully and qualifies as an immediate relative of a U.S. citizen may still have strong adjustment eligibility protections. Meanwhile, another applicant with prior unlawful presence or visa complications could face much greater risk under stricter interpretations. This is why generalized fear online can sometimes become misleading. But despite the confusion, one thing is absolutely clear. USCIS scrutiny appears to be increasing again in 2026. Applicants are being reminded that immigration benefits are never automatic. Every application must be accurate, complete, honest, and legally supported. Small mistakes that once may have been overlooked could now trigger serious consequences under a tougher review climate. Another important concern involves travel. Some immigrants are now terrified of leaving the United States even temporarily. People with pending cases worry that reentry could become more difficult or that new interpretations may affect advance parole approvals. Others fear that international travel could expand